From the National Association of Consumer Bankruptcy Attorneys, this is NACBA Now, with your hosts Gene Melchionne and Jim Haller, discussing bankruptcy law for the busy consumer bankruptcy attorney.
Hello, Gene. How are you?
It's a sunny day. I'm fine. Everything's fine.
Oh, I'm glad to hear that. Well, we're here for another NACBA case law update. This is the case law update published on October 5th, 2023. And I'm Jim Haller, and
I am Gene Melchionne.
yes. So we're going to go through the cases that that were listed last week. The first one, interesting case, Duval versus Ontario. And you were talking a little bit about this before, how you found it interesting. You want me to kind of go through the facts a little bit on this, or
a little bit, yeah. This is I see this case from both sides because I used to do creditor work, and obviously I do debtor work. So it had interesting positions presented on both sides.
So this is an interesting situation where prior to filing the bankruptcy, the debtor was behind on real estate taxes, and they were purchased at a tax sale within the fraudulent transfer period of time. Debtor filed a Chapter 13 and filed a motion to avoid the tax foreclosure as a constructively fraudulent conveyance under 548 of the bankruptcy.
Clever.
So one other piece of this puzzle is that the debtor also had a retirement fund and had claimed it as exempt on her schedules. The tax buyer did not object to that exemption. And later, when the judge was determining whether or not it was a fraudulent tax transfer, they were arguing, well, if the exemption wasn't there, then she wouldn't be considered insolvent when the transfer occurred pre-petition. Right. And the creditor argued that essentially the fact that they didn't object to the exemption really is not relevant to the determination of whether or not she was insolvent, because essentially that exemption was no good anyway, and her assertion of the exemption in bankruptcy really didn't apply to the transfer that had occurred prior to that. So kind of trying to get around the fact that they failed to object to the exemption of this asset. Mm-hmm. Your thoughts? What do you think? What do you think they're going to
do? This was a clever case, and it's one that I think people should read the decision in depth, because you've got a situation where a piece of property was foreclosed under a tax lien sale and then avoided, and the defense of the taxing authority is that, well, there's this annuity that wasn't exempted, so that means that she wasn't or the debtor wasn't insolvent at the time of the transfer. It's clever. It's just wonderful, the stacking of mistakes that were made here, because it sounds to me like if the creditor had objected to the exemption, then the argument about avoiding the transfer of the property would have gone away. It's clever. That was my first reaction to this case.
Unfortunately, Second Circuit didn't buy it.
Yeah.
And to quote the Second Circuit, it said, the county reasons that the absence of an objection to the exemption cannot affect whether a debtor was insolvent at the time of a pre-bankruptcy tax foreclosure, because such an absence is relevant to what property belongs in the bankruptcy estate only as of the commencement of the bankruptcy proceeding. And the next paragraph starts off, the county's logic conflicts with the logic and text of the statutory scheme. Yes, they are allowed, and it said the plain text of the code contemplates that insolvency is determined based on the debts and properties and exemptions from the bankruptcy estate. So the court shut him down and allowed, I think it affirmed the avoidance of that transfer. So good battle, and hopefully the debtor will be able to make her payments and get rid of that debt. So
I'm all I could say about reading this case was, holy cow, that was incredibly clever for the debtor's attorney. Did a great job in it.
yeah, absolutely. Next case, In re Ross, out of the bankruptcy court from the District of Columbia. We don't get too many opinions from DC. This one was I had to read it a few times, but it was kind of interesting. There's a Chapter 7 trustee who had evidently been practicing for a long, long time, and he had a quote-unquote business relationship with an auction house, and evidently the trustee would receive a referral fee for shooting business their way, and the trustee did not fully disclose this relationship in his fees to the bankruptcy court, and this became obvious in this particular case, and the court went back and looked at other cases where the trustee was involved and whether or not the money had the referral fees had been disclosed. The trustee ultimately resigned as the panel trustee before this decision was made, and the trustee basically said, well, I had disclosed it in a certain way and nobody had ever objected to it before, the way I disclosed it. And so I just assumed because there were no objections that it was sufficient. Now, maybe it's just the fact that we're debtors attorneys, and I know we would never get away with that explanation, not in a million years. But the court said, well, he's already resigned. We'll supervise him for his last 5 cases, and he needs to disgorge about $30,000 in these referral fees. I thought it was a good case, and I thought it was a just case that this was published, because we often hear about debtors attorneys having to disgorge for not disclosing in fees. And I think it's appropriate that the court holds everybody to that high standard. So,
totally agree. And
yeah.
my reaction to the previous case was summed up in one word, which was clever. This one was yikes, because it was mind-blowing, because you don't hear about these kinds of cases very often, and you do hear about debtors attorneys having to disgorge fees all the time, but never trustees. And holy cow, here it is. And the practice was it just blew my mind. I read it and I went, holy cow, yikes. I would not want to be that trustee.
Yeah.
The definition of the word.
So disclose.
Right.
Bankruptcy attorneys, we live in a different world than I think any other field of law, where everything is under scrutiny. All of our fees are under scrutiny. And all right, next case, In re Acosta, out of the bankruptcy court in Kansas. I included this because the case, in the opinion, was a great primer to anybody having to defend a 523A6 action. 523A6 makes non-dischargeable debts that are as a result of a willful and malicious injury. And in this case, the court goes through, talks about what willful and malicious mean, and determines whether it was willful and whether it was also malicious. And in this situation, prior to the debtor filing the bankruptcy, the the debtor had been found civilly liable for stalking and harassing the plaintiffs slash creditors, and then he filed a Chapter 7, and the creditors slash plaintiffs filed this adversary against him. And so the court made a couple of interesting rulings here. Number one, the standard of proof is not beyond a reasonable doubt. And instead, it's the preponderance of the evidence. It talked about willful and malicious and defined willful. For an injury to be willful, there has to be a deliberate or intentional injury, not just an intentional act that leads to an injury. And you also have to show that it's malicious. You need evidence of the debtor's motives, including any claim, justification, or excuse. And malicious behavior is both intentional and wrongful. And the court found that, yep, this qualified. But I thought it was a great case. I mean, anybody looking to get a primer on 523A6, this is a fantastic case to look at it. In this case, the debtor was not successful, but I could certainly see a lot of situations where you could take the lessons from this case and use it to defend a debtor from this type of an accusation.
Absolutely, no doubt about it. The way I looked at it, and again, another word to use to describe the case, textbook. This was the definitions were clearly defined. Everything was explained, and the court applied those definitions to the actions in the case, and poof, you've got your ruling. It was a no-brainer.
Yeah. Now, the last case is, I find very interesting. It's Ovation versus Morgan. This was an appeal to the district court for the Southern District of Texas. And this is, in this situation, the debtor, again, fell behind on real estate taxes, filed a Chapter 13 to get him caught up. In the Southern District of Texas, there is how do we call it? Required non-standard language. and that basically mirrors Bankruptcy Rule 3002.1 for any creditor that has any security interest in the debtor's real estate. And in this situation, prior to the bankruptcy being filed, the debtor had worked out an arrangement to repay his tax debts. The debtor fell behind on that. The debtor put the creditor in the bankruptcy plan, and the bankruptcy plan, it basically said, well, you have to notify, you have to file a notice with the court within 6 months of incurring any fees or expenses. And the creditor came back and said, well, hold on a second. 3002.1 doesn't apply to us because that's a security interest in the debtor's principal residence, for which the plan provides that either the trustee or the debtor will make contractual installment payments, in that it claimed that its statutory tax lien was not a security interest as defined by the Bankruptcy Code. And I think they've got an argument there. The Bankruptcy Court said it doesn't make a difference because we're not necessarily applying 3002.1 to you, but the Chapter 13 plan provisions that essentially mirror 3002.1, it is the Bankruptcy Court has the authority to include those in there under Section 105 of the Bankruptcy Code, because the goal of the 13 is that at the very end of the bankruptcy, the debtor emerges from bankruptcy with the lien paid off, and any additional fees or costs that were incurred by the tax buyer that are properly noticed are also paid for. So the debtor emerges with this lien out of it. And the creditor argued, Well, that really affects our state lien rights. We're allowed to charge additional interest and attorney's fees, and we shouldn't have to go back to the bankruptcy court to get permission from those because the state law says that we can charge those. And the district court said, no, the bankruptcy court is right. There's no violation of your statutory rights by imposing this procedure. It doesn't mean you can't get those fees. It doesn't mean you can't, charge that interest. You have to disclose it. And that was the big issue. And this case is being appealed to the Fifth Circuit. Thoughts on that?
It's interesting. I once conferred with a group of Massachusetts attorneys, which is right next to Connecticut, and went to Massachusetts and said, I can't believe that you guys are actually part of this country. The rules you have here in Massachusetts are totally foreign to me. The same feeling erupted when I read this case about Texas because of this incorporation of the concept of 3002 into the plan. It left me speechless. I was like, what? I don't get this. But after thinking about it a little bit, okay, they have a procedure there in Texas that's unique to Texas or maybe in some other jurisdictions. And so the creditor didn't follow the procedure. That's all. If they followed the procedure, they would get their money. Right. Put the notice on that you're going to incur this interest or you're going to incur these attorney's fees, and you get paid those as part of your security. And I get this distinction about security interest and what the court did there, but it's just foreign to me, I guess is the best way to put it. There's another one of those keywords.
Well, I mean, I like this case because it's very clear that despite the fact that 3002.1 may not apply, the same type of noticing requirements that are in 3002.1 can be imposed.
Right.
In order to meet the goal, which is to let the debtor emerge from Chapter 13 bankruptcy without the lien and having everything paid. And so there's something that kind of doesn't sit right with me for a creditor to say, we don't want to have anybody supervise what, or approve what we think should be charged against the debtor.
Right.
It's kind of, to me, my opinion, that seems kind of like hiding the ball there. And like we said in the previous case, when you're in bankruptcy,
disclose.
You're going to charge fees. You got to get the judge to say, okay, you can't hide the ball. So.
And the thing is, in this case, that's all they needed to do. They could disclose it and they would get paid. It's not that hard. It's not rocket science, although it may feel like it a little bit coming from another part of the country. But sure, I mean, it made sense once I thought about it a little bit.
Absolutely. Well, Gene, that's all we had for this week. We'll be back again for another case law update in the future. Until then, it's great talking to you. And everybody,
always fun.
Yeah, take care.
Okay. Bye.
Thank you for listening to NACBA Now and your continued support of NACBA. You can find additional materials to assist you on the member dashboard page at nacba.org. Educate, advocate, litigate. NACBA.